Let's check the mics. Can you hear us in Chicago?
Yeah, yes.
Welcome, Catherine. I hope you didn't run too fast.
Oh, I can't walk as fast as I used to still, but.
I know, that's what I'm afraid of. All right. It is a little after 10 on September 16th, and I will call the Illinois State Board of Elections meeting to order. If you'll all stand, we'll start with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, liberty,
justice for all.
Amy, roll call, please.
Ms. Ballard-Croft. Ms. Craig. Present. Ms. Genovese.
Here.
Ms. McCrory.
Here.
Mr. Brett.
Here.
Ms. Watson.
Here.
Vice Chair Turbin.
Here.
Chair Donahue.
Present. All right, we'll have the start with the approval of the minutes for August 19th. Are there any corrections or questions or anything? If not, I'll take a motion.
So moved.
To accept the minutes.
Second.
Roll call, Amy.
Ms. Ballard-Croft.
Yes.
Ms. Craig.
Yes.
Ms. Genovese.
Yes.
Ms. McCrory.
Yes.
Mr. Brett.
Yes.
Ms. Watson.
Yes.
Vice Chair Turbin.
Yeah.
Chair Donahue.
Yes.
Motion passes.
All right, we'll start with the report of our general counsel. Marnie, if you want to begin.
Certainly. Good morning, everybody. We will start with campaign disclosure. Our settlement offers will come first, and it sounds like 2A1. Excuse me for 1 second.
Yes, she's present.
Okay, sounds like 2A1 has arrived, so I will call that case. It is SBE versus Stadelman for State Senate, 24 AD 30.
Mr. Stadelman, are you in Chicago, please, if you'll come forward?
Right here, Chris. Yep, right there. Yes, he is.
Marnie, if you'll proceed, and then we'll have Mr. Stadelman begin.
Excellent. So the committee is offering $5,000, which is 50%, to settle $10,000 in fines for late filing of 9 A1s during the fourth quarter of 2024. The committee does not meet the guidelines for balance or ratios, which are for balance or receipts ratios, which are 3.9% and 10.9% respectively. The committee is also not considered low dollar, with an average ending balance of $255,477. The offer does, however, meet the 50% benchmark. The committee offers 2 potential mitigating factors for consideration here. First, the committee had no prior violations before this group of A1s. And second, although the committee did not appeal the fines or file a timely motion to reconsider, it does appear that one of the 9 A1s here was not actually untimely, and had a proper appeal or motion for reconsideration been filed, the fines likely would have been $9,000 and not $10,000. Here, I recommend denying the offer because the settlement factors in section 9-10 and rule 125.425 weigh against settling. However, if the board does want to settle, it could consider that the committee has a violation-free history. The violations were unintentional. The contributions eventually were disclosed, and $1,000 of the fine appears to arise from a potential clerical error.
Mr. Stadelman, if you'll, you have an opportunity to speak. I'd ask you if you'd state your full name and spell it for our court reporter, please, before you begin.
Sure, thank you. My name is Steve Stadelman, last name spelled Stadelman, State Senator, 34th District. And I'd just like to proceed. First of all, I apologize. I was not even aware of the board's initial decision. I was in Springfield, obviously, through the months of April and May, and did not check my post office box in a timely manner. And so it was June before I actually got a chance to check and find out the violations that allegedly occurred. I would have appealed. There is one violation, a 50,000 donation that was reported in the A1s. However, the other 8 apparently were not reported. I filed all those checks in one batch in my bank account, and I miscommunicated my staff as far as making sure the A1s were filed. Ironically, there a batch were filed 10 days before and a few days afterwards. So it's just one-time occurrence where I deposit these checks at one time. It was just obviously miscommunication, mistake at one point. So I'm just asking for leniency with the settlement offer this time around.
Thank you, Mr. Dadelman. Questions? Do I have a motion?
I make a motion to accept the settlement offer, and bypass the general counsel's recommendation.
I second. Been moved and seconded. Roll call, Amy.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Mr. Nevesi,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
yes,
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes, and I would ask the indicator, Catherine, for when your motion, are we going with the 5,000, which
Correct.
settlement offer?
Correct.
It's been approved,
And motion.
motion passed. All right. Next up, Marnie?
We also have an appearance for agenda item 2A2, that's SBE versus Friends of Adair Rodriguez, 23 and F 52. And I understand candidate Rodriguez is here in Springfield.
Yes. Yes, I'll bring you the mic in just a minute. I'll have you state your name, spell it for our court reporter, Marnie.
Great, so I'll read my recommendation first and then you'll have your opportunity, Mr. Rodriguez. So here the committee is offering $250, which is 5.81%, to settle $4,300 in fines for late filing or failure to file the September 2021 and June, September, and December 2022 and March 2023 quarterly reports. The committee's settlement offer form was missing some information, so campaign disclosure included an amended form in your packets. The committee was administratively terminated in January 2024 after not filing reports after the second quarter of 2022. Mr. Rodriguez included bank statements with his offer showing the committee's last reported balance of $203.58 was depleted since then by monthly bank fees. So it does not appear the committee has any money left at this point, and the committee is closed because it was administratively terminated. Mr. Rodriguez is hoping to run for office next year, and the committee meets the balance and receipts ratio. And although the offer is below 50%, the committee is considered low dollar. So under these circumstances of a closed committee with no money left, I recommend accepting the offer as the settlement factors weigh in favor of acceptance.
Yes, my name is Adair Rodriguez. That is Adair, Rodriquez. Yes, thank you for the opportunity to speak. The committee has been closed, as mentioned before. Frankly, so many years ago, I ran for office. Obviously, I didn't win. After that, I would love to be able to remember what my state of mind was at the time, but frankly, it was a few years ago. But as you can see, I don't have money in that account anymore. But I do appreciate the recommendation. As mentioned, I am hoping to run for office again. And frankly, at this point, I had forgotten the old committee had even existed until I was trying to do my due diligence for this next run for office. The dream is, if you will, that this new committee will be able to afford the $250 that I offered to settle the case and get it done and dealt with.
Thank you, Mr. Rodriguez. I believe I'm correct. If we accept the offer, 250, you have 30 days. Make that payment.
Unless the board chooses to extend that period.
Would you be
able to do that in 30 days?
Frankly, I'm not confident in my ability to do it in 30 days, so an extension would be greatly appreciated.
We put that in the motion?
Yes, whatever time period you think is appropriate.
Can we say it where it says that you can work it out with Tom to no one's coming up? Instead of setting a date.
Yeah.
We can't hear you very well down here.
You can't.
Oh, that's my phone.
I'm sorry, guys.
Is it better, Marnie, to put like 6 months? To put a definite time frame on it?
I would probably prefer that as to putting
Yeah,
no
I believe
time
a
on it
time frame should
whatsoever.
be-
I think it's clear for the
Yeah.
record.
If I could just say, yeah, effectively, there is a deadline, which I believe is January 8th, which is the ballot certification date for
Oh,
the
okay.
election.
All right.
So, yeah.
So,
that's even less.
we say, do I have a motion to accept the recommendation of our general counsel for accepting the fine paid to the state board by January 8th?
So moved.
Second.
Amy, roll call.
Ms. Ballard Croft,
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Can you hear us now? Was that, thank you, Mr. Rodriguez. Good luck. Can you hear us? So it is just the mic being over there that goofed us up, right?
Correct.
Gotcha. All right. Marnie,
Next agenda item 2A3. Is anyone present on behalf of Friends of Marcus Herbert for sheriff?
anyone in Chicago?
No.
There's no one here?
In that case, the recommendation is to deny the settlement offer.
Do I have a motion to that effect?
So moved.
Second. It's been moved and seconded. Amy, roll call, please.
Ms. Ballard Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
All right. Marnie, appeals of campaign disclosures.
Yes, so we have one appeal in which the hearing officer recommends granting the appeal. That is agenda item 2A4. I agree with that recommendation.
Go on.
Because the contribution was mistakenly reported on the date of receipt instead of the date of the notification from the in-kind contributor. So the recommendation is to grant the appeal.
Do I have a motion?
So moved.
A second?
Second.
It's been moved and seconded. Amy, roll call, please.
Ms. Ballard Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Marnie, next up.
We next have a chunk of cases in which the hearing officer recommends denial, and we have quite a few appearances. So I will take those in order first. Agenda item 2A5, SBE versus McDonough County Democratic Central Committee, 24 AD 13. We have an appearance from Treasurer Beth Nelson.
Yes, she's coming. When I bring you the mic, state your name and spell it. Marnie, if you want to continue.
Great. So the committee is appealing a $1,000 civil penalty assessment for the 20-day late disclosure of a $1,000 contribution dated November 20th, 2024. With its appeal affidavit, the committee submitted multiple documents showing that November 20th was indeed the date of deposit, but it was not clear what the intended argument on appeal was in the written appeal notice. At the appeal hearing, the committee stated for the first time that it mistakenly believed that entering the contribution into IDIS was the only thing necessary to file an A1. Here, I agree with the hearing officer that the appeal should be denied for a lack of a statutory basis, as there hasn't been any defense offered.
Mrs. Nelson?
I'm Beth Nelson, Beth Nelson. Go ahead. Oh, well, first of all, I realize ignorance of the law is no excuse. I understand the ethics of being a treasurer, but I'm not good with computers. And I'm little motivated to learn. I guess I need to get over that. We can't afford a CPA. So we depend on volunteers. And last year at times we had a lot of money. At one point we had nearly $17,000 and we donated 1,000 to the food pantry. But we try to manage what we have carefully. I try to get my quarterly materials done early, and I often get feedback that I need to get more information. I've kind of been depending on that. And finally, this will not be repeated. When I get a $1,000 donation, I will call the board and go through the steps. I've already done that once to make sure that I get it completely filed. It was the A1 report that was missing. And so the last time we did that, I got that taken care of through help from the board.
Thank you, Ms. Nelson. Is there a motion? Questions?
I'll make a motion to accept the recommendation of the general counsel and deny the appeal. Just so you're understanding, Ms. Nelson, we don't really have much of a choice. We're statutorily bound at this point, and I think your remedy might be in your settlement offer as opposed to winning an appeal at this point.
You make a settlement offer?
No, that's quite all right. You just leave it over here. Yes, you can make a settlement offer. And then, go from there.
Okay, then that would be heard here again.
You can make it right now if you wish. We normally accept like 50%.
So in this particular case, even a 50% offer, because there's a current average ending balance of $6,077.65, the balance and receipts ratios are only 16.45% and 21.34%. So it's not a perfect offer.
If I can, I would second the motion and then give the party.
Wait a minute, Jack. There's another sound coming in.
There's some in the room next door to us. I don't know why it's so loud, but it's feeding into our room right now.
No problem. Go ahead, Jack.
Because Member McCrory made a motion, I would second the motion, and I don't want this party to feel under pressure to come up with a settlement offer, given the balance of their receipts. So maybe she could work through that with Tom off screen. And if she wants to make an offer today, she can, or she can come back at a later date. But I certainly don't want to pressure her into making an offer right on the spot. So I would second the motion and go from there.
Thank you, Jack. Yes, it's been moved and seconded. Amy, roll call, please.
Ms. Bellercroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese, Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Chair Donahue.
Chair Donahue,
Yes.
motion passes.
Andy, is it?
And the appeal is denied.
Or is it? Not much.
There. Just for this, what's the volume from our neighbor next door? Is it a distraction to you? I think
No.
we can probably ignore it, but well,
It just wasn't that moment.
okay. Andy's gonna go speak to them.
Well, we'll see if it's even something we can request.
It was just that one, when you started to talk, they were talking but we
Yeah.
haven't heard until that moment. So, all right, Marnie, continue, please.
Okay, next is agenda item 2A6, SBE versus Citizens for Polk. We have on file an appearance from Mr. Polk. I will read my recommendation and then Mr. Polk will have the opportunity to respond. Is he in Chicago?
In Chicago?
Okay, excellent. The committee is appealing an $11,500 civil penalty assessment for the disclosure between 14 and 48 days late of 7 contributions totaling $11,500. 6 are dated in January 2025, and 1 is dated March 17th, 2025. Additionally, the committee failed to file an A1 for a contribution of $1,250 dated February 10th, 2025. The contribution was first reported on the committee's March 2025 quarterly report, 38 days late, resulting in a fine of $1,250. The total for all pending assessments is $12,750, the full amount of the contributions. The appeal affidavit accepted responsibility for the late filings, noting the committee has been in existence for over 25 years. And the appeal affidavit also expressed frustration about misinformation in the latest campaign. Here, I agree with the hearing officer that the appeal should be denied as there's no statutory basis to grant it.
Mr. Polk, would you please state your name and spell it, please?
Yes, my name is Robert Polk, P-O-L-K, Robert Polk.
Continue.
Sure, but keep your voice up if you could, please.
Yes, my name is Robert Polk, R-O-B-E-R-T, Polk, P-O-L-K.
Go ahead.
As I appear before the committee today, and I don't really, as I said, I've had this committee for 25 years that I've been over, and I just really cannot conceive that, really did not do it, but I must have been just exhausted from the campaign, and it was a lot of work and a lot of stress and stuff. So I do take responsibility for it. I apologize for it. I'll make sure that this will not happen again over the next 25 years if I'm still alive. So, or whatever the case may be. So, but I try to run a responsible campaign and do the things that I should do, supposed to do, and I also try to do things in a Christian manner. So I definitely want to make sure it's right, correct. So I really cannot imagine that it went that long. It has never gone this long before, and will not ever go this long again.
Thank you, Mr. Polk. Are there questions? I'm not sure we have any discretion in this matter, but do I have a motion?
Yeah, I would just say, similar to the case before, we are statutorily bound. However, I think that your opportunity will come in the form of a settlement offer after this vote. So I will move that we accept the hearing officer's recommendation and deny.
Second.
Thank you. Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCory?
Yeah,
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passed.
I believe Mr. Polk, Andy Nauman should be in the office up there. If Andy, if you identify yourself, if you'll talk to him, he'll kind of walk you through what your next process is.
He's ready now, he says.
Oh, okay.
So what option do I have as far as all goes?
well, I
Okay.
don't think you're ready now.
Okay.
Good.
If you can talk to Ms. Tanover.
So he's talking to Andy, is that right? Okay, go ahead.
So we can move on.
All right, the motion was accepted. All right, Marnie, you next.
Next item is agenda item 2A7, SBE versus Citizens for Annette Lidower, 24 AD 23. Is the candidate present in Chicago?
Yes.
Yes, I am.
Excellent.
This
The
way or.
committee-
See that green light on the ceiling in front of you?
Yeah.
That's what, yeah.
Okay,
There you go.
okay.
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 So I'll first read my recommendation. The committee is appealing a $300 civil penalty assessment for the 12-day late disclosure of a $1,000 contribution dated December 14th, 2024. The committee has a previously stayed penalty of $30 for late filing of the September 2023 quarterly report for a total of $330 in fines. The candidate says her online donation platform was using an outdated email address to inform her of contributions, and she has since corrected this issue. Here, I agree with the hearing officer that the appeal should be denied for lack of a statutory basis. It is the responsibility of the committee to ensure it tracks deposits into its accounts and timely discloses them if required.
Thank you, Marnie. If you'll step forward, state your name and spell it, please, for the court reporter.
My name is Annette Littwer, ANNETTELID like a David, AWER. I am the candidate, and I just wanted to bring forward a few other facts. I'm not sure it complies with the statutory requirement in either case, but I thought that the additional evidence might somehow be germane, so I wanted to bring it up to you. And in lieu of that, I would ask if I could also go forward with if it doesn't meet the statutory requirement. In any event, I've had my committee for 16 years. I've run every single consolidated election, save for getting on a different schedule because I was at first on the school board and then was off for 2 years, and then I ran for the city council, both of which are in Highland Park, although District 113 covers 5 towns on the North Shore. I have kept my account open throughout the duration of those 16 years, even though the office was different. And I have filed a quarterly report every single time, except for the one time when it was slightly late. I thought I had hit send and I didn't. So that was a little bit of a shocker, and that's why that was put on hold since it was my first violation. But because this came up, it comes in again. In any event, when I filed in November of 2024 to run for office again as an incumbent, there was a full slate of candidates and it was a competitive race. And shortly after the filing date, one candidate was, he took himself off of the ballot and it became an uncontested race. At which point I sent out notification via Facebook, via email, and even I actually put up signs saying this is not a contested race. Don't send me money, you know, and I received literally no notifications to this email account so that no constituents appeared interested. I heard from a lot of people on my personal email account saying, congratulations, basically, you have no race. But there was nothing. If anything, I wasted a lot of money on putting together a new website and everything, but there were absolutely no hits. So when I went to file my report, I realized that in between a bank statement and in between my filing date, 4 people did actually contribute. 3 like $25, you know, I don't know if they thought it was Christmas, and so they sent me $25 when I didn't have a race. And one person actually sent me a $1,000 check. I had no knowledge of any of them because the company that I've used since I guess it's 25, so 21, since 2021, I had changed the email address from my original, you know, Annette Littwer for City Council to re-elect Annette. And so they didn't have the correct email. So even though they may have sent me a notification, although there are none in my EBOT email, and I actually asked them, as did the hearing officer, for any communications notifying me of the $1,000 contribution, there was no communication. So when I went to file my quarterly report, that's when I found out about these 4. And at that point, I obviously filed it immediately. I actually filed it within 24 hours notification, but that was not within the regular time frame. So I just thought that those circumstances did make somewhat of a compelling case and statutorily sufficient. So if that's the case, I would like to do it with in the alternative as some sort of settlement.
Not to sound like a broken record, but we're right back there.
Gotcha. After hearing that, I kind of got it by the third
Yeah,
time.
we don't have a statutory basis to grant your appeal at this point. And so again, just like the two people before you, it's gonna be more discretion with any settlement offer you might want to make. So at this time, I would make a motion to accept the general counsel's recommendation and deny the appeal.
Second. Thank you, Catherine. Thank you. Thank you, Mrs. Lidwer. Amy, roll call.
Ms. Ballard Croft,
Yes.
Ms. Craig.
Yes.
Ms. Genovese, Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
yes,
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passed.
All right. Thank you. Marnie, next step.
Next is agenda item 2A8, SBE versus Paul C. Bryson Senior, 25 NF 125.
I believe Mr. Bryson is in Chicago.
Yes, yes.
Yes.
All right, Marnie will read her recommendation and then we'll give you a chance to speak. Marnie, please.
The committee is appealing $2,500 in civil penalty assessments for failure to file the December 2024 quarterly report, as well as the March 2025 quarterly report. The committee has unpaid previous penalties totaling $510 for late disclosure of the December 2022 quarterly report and the failure to file the September 2024 quarterly report. The total for all pending assessments is $3,010. The committee's treasurer said she misunderstood the filing requirements following minimal financial activity and asked for a waiver of the $2,500 fine. On July 22nd, 2025, 4 days after the date of the assessment notice, the committee filed all outstanding quarterly reports. Here I agree with the hearing officer that the appeal should be denied for lack of a statutory basis, as the law requires quarterly reporting for all open committees.
Mr. Bryson, please state your name and spell it, please.
Paul Bryson, Paulbrysson.
Thank you. You can continue.
Well, I'm here to request that the appeal. Just a misunderstanding, miscommunications on our end. This was a first time campaign. Actually thought we had dissolved it. That didn't happen, and things just it was just a misunderstanding of the filing requirements and the dates and things of that nature. So I don't really have anything else to really offer other than what my treasurer sent in to you all. So that's where I stand.
Thank you, Mr. Bryson. Do we have any comments, questions?
Thank you.
Do I have a motion?
Do you intend to run again?
No, I don't.
Able to,
If you don't intend to run again and
I
your
don't.
committee, so again, we don't have a statutory basis to grant your appeal. Okay, so we're in the same position we are with everybody else. If you don't intend to run again for the next 2 years at least, then even though we deny your appeal, your fine will be abated. But if you open that committee within the next 2 years again, or any other committee related to you, the fine will come back at you and you will not be able to open the committee until you settle the fine. So if you have no intention of running at all,
I don't.
okay, then we would be in a position where we would have to deny your appeal request. And then the fine would stand, and if you don't run again, then after 2 years, it will abate.
if the committee is dissolved,
If
if
the
it's
committee is
properly dissolved.
Right,
Yeah, and that's what we thought it had been done, but we actually kind of thought when we lost the election that
So-
was pretty much it.
Yeah,
But
right. So you'll need to go through that process, and then if you don't intend to run 2 years, it will abate. So with that, I'll move to accept the hearing officer's recommendation, deny the appeal.
so who has the right to grant the appeal?
You said you all don't
We,
have that.
we are bound by the statutes of what appeals, what's a legitimate appeal and what's not, right?
Okay,
Your mistake, or whatever the reason was, unfortunately, is not any grounds to grant an appeal. We have specific, like, for instance, if there was some sort of a computer mistake, and then within 3 days you notified, the Board of Elections that happened, and they worked with you to rectify that, that might be the grounds for an appeal.
Gotcha.
But in this instance, it's not, unfortunately.
so what are we saying is gonna happen now?
So if we're gonna deny the appeal, and you're gonna talk to Mr. Nauman about dissolving your committee, and if
Okay,
you don't run again or form another committee for 2 years at least, then that fine will abate, meaning it'll go away. But if you open another committee within those 2 years that you're involved in and that you're running for election, that fine will come back.
I understand. Thank you.
Thank you, Mr. Bryson. Talk to Andy.
Thank you.
Do we have a motion?
We need a second.
Second. It's been moved and seconded. Amy, roll call, please.
Ms. Bellercroft,
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin? Chair Donahue?
Yes.
Motion passed.
All right, Marnie.
Okay, if we can head back to agenda item 2A5, the McDonough County Democratic Central Committee is ready to make a settlement offer. So if we can hear from Ms. Nelson about what that offer is.
Yes, we would appreciate the opportunity to pay $500 instead of the whole 1,000.
Thank you. Ms. Nelson has made an offer. Do I have a motion to accept?
So moved.
It's been moved and seconded. Amy, roll call.
Ms. Bellercroft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passed.
All right, Marnie.
Is anyone present on agenda items 2A9 or 2A10?
We have,
Can I interrupt for just a second? We've got settlement offers on 2A6 and another settlement offer on 2A7.
Great. All right, well, let's head back to 2A6 and hear about Citizens for Polk's settlement offer.
Mr. Polk?
Yes. I would offer, and hope that it would be acceptable if I could pay a third of it, like, I don't know what that would be, 3,000 or something, whatever. Third of that amount, what that be? Would that be something
Well,
you
you,
could
I think you
consider?
need the exact, yeah. And
12,750 was
the
the,
fines are, the total of the fines are $12,750.
Okay.
was the third.
That, yeah.
So that would be, if you would like to offer a third of that, that number would be $4,250.
Okay,
Now, whether we can accept that or not, we're gonna defer to our general counsel right now. Maybe she needs to do some math.
okay.
Marnie?
Okay,
Comments?
so this committee's average ending balance is $11,221.99. So this is not a low dollar committee. That having been said, the ratios are favorable. So normally here we would want a 50% offer.
Mr. Polk, would you be willing to offer $6,375 for 50% of the fine?
I couldn't offer anything less than that.
Well, that's up to you. I mean, we could have a motion on the first offer and see where we are.
Okay.
So the first offer was $4,250. Yeah.
All right, Catherine, go ahead. Somebody said something. Catherine, what did you say?
The first offer that Mr. Polk made was $4,250. He would like us to make, to rule on that.
And I'm sorry, I just need to refresh recollection. Were these first violations? Have you come before us before? Have you had violations? And the committee's been open for 16 years, you said?
25.
25 years.
And I'm taking a look at the
Hang on
packet.
just a second, guys, we're taking a look.
But it,
I think I had a $300 fine one.
yeah, that's, it looks like there was a fine in 2022.
Yeah, he had two.
I make a,
There was a,
So the-
2022 for $50 and 2024 violation. So this is the third.
Member Chairman wanted to say something.
That's correct.
Yeah. What's his balance?
12,750.
What's his like campaign balance?
$11,221.99.
So just to be clear, Marnie, am I reading this correctly, that there was a 2022 violation and a 2024 violation before the
That's
20
correct.
violations?
what were the?
There were 2 prior violations, so this is a 3rd violation through a 10th violation.
How much were the other two?
I'm gonna see if our director, Tom Newman, has the exact number.
So yeah, previously in 2022, the committee was fined for a B1 violation, which was $250. That was not appealed. The committee paid it. And then in 2024, there was a $50 penalty for late filing of the June quarterly report of 2024. Also not appealed and also paid.
I make a motion, we take the $4,250.
Second,
Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig,
No.
Mr. Nevesi? Yes. Ms. McCrory,
No.
Mr. Pratt,
No,
Ms. Watson,
yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
No.
Motion failed.
Motion
4-4.
fails.
I think that if this was the first violation, it would be different, but this is the third violation. And we are offering, I mean, I would agree to a 50% settlement offer because this is the third violation. So I'll make a motion. Well, I can't make a motion. Mr. Polk. At this point, the motion to accept your $4,250 offer has failed. So you have an option to make another offer. You do not have to make it today. You can think about it. I don't want to force you into anything. Nobody wants to force you into anything. So if you want to think about what that offer would be, alternative offer would be,
I would like to get it resolved, so I can get it off my mind.
So we will need just an offer from you then, if you wanted to revise your offer.
so you had asked me to do the math for you, and I have to do it with a calculator because I went to law school because I can't do math. So.
I believe it's $6,325 or $75, $6,375. I can't read my own handwriting, which also means I'm a lawyer.
Exactly. $6,375 would be a 50% loss.
So I couldn't offer 5, this money is hard. I don't ask people.
but you can offer whatever you'd like to offer, but we have as a board set guidelines so that we treat everyone the same and that we have different factors that we take into account when we're assessing a settlement offer, whether it's appropriate, so that big committees get treated the same as small committees, people that have had a lot of experience get treated the same way. And so you can make whatever offer you want, and then you can argue as to why you think that we should grant you leniency in one way or the other. But it sounds like you're hoping to get us to get to deviate from our guidelines without giving us a reason to. And if you have a reason, please share and we can vote on that. Or you can think about it. There's no rush. There's no deadline that you have to meet today.
Yeah, but I would have to come back, right?
But, or you can make a settlement offer, and if it meets the, you know, guidelines, and it is, the general counsel says that she recommends that we accept it, then you don't necessarily have to be here.
Yeah, I go with the 50%, you know.
Did he say 50%?
I'm sorry, I didn't hear what you said.
They need to speak louder.
In the 50%, I go with this.
So that,
So that is the $6,375. Is that correct? That's what my calculator says. $6,375.
Well, it's like
That would be-
11,000 something to fund, right?
Right. Well, from what our records say, you have $11,547.84 in your bank account.
Right, so I'm up at 50% of that then.
No, 50% of the $12,750.
our guidelines recommend 50% of the fines owed, and the fines owed are the 12,000.
Will those include the in-kind contributions also?
I'm sorry, I couldn't hear the question.
I said,
Yes, those include the in-kind contributions.
so that was 2 in-kind contribution that was also, you know, which actually was not money. So that would,
I'm gonna let you take that from there, Marnie.
Okay, the contributions that are included in this offer, to the best of my understanding, would be the 6 violations in January 2025, the violation dated March 17th, 2025, as well as the late March 2025 quarterly report, which is a fine of $1,250. So the total is $12,750.
okay. Okay, then we'll go with that.
Are you right? All right.
So you have to
All right.
articulate, your offer is $6,375 or something different?
Yes, my offer is 6,300, how much, $75?
That's what my calculator says.
Okay.
Do I have a motion to that?
I move to accept Mr. Polk's settlement offer of $6,375.
Second,
It has been moved and seconded. Amy, roll call, please.
Ms. Ballard Croft,
yes.
Ms. Cray,
Yes.
Ms. Genovese, yes. Ms. McCory,
Yes,
Mr. Brett,
Yes.
Ms. Watson,
yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes,
Motion passes.
thank you, Mr. Polk.
Yeah.
And I have to pay-
And then there was one for 2A7 proposal. 2A7,
So if Ms. Lidower would like to come forward and make her settlement offer.
yes.
she's right here.
Yeah, I'm here. Thank you. It's Annette Lidower again, and 50% of my $330 outstanding violation is $165, and I would like to propose that I do a settlement to that extent.
I
Do
move
you have a
to
motion?
an offer.
Second,
It's been moved and seconded. Amy, but roll call, please.
Ms. Ballard Croft,
yes.
Ms. Cray,
Yes.
Ms. Genovese, yes. Ms. McCory,
Yes,
Mr. Brett,
Yes.
Ms. Watson,
Yes,
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes,
Motion passes.
Thank you. Thank you.
all right. Are there anything else up there at this point? All right, Marnie?
For agenda items 2A9 and 2A10, the recommendation is to deny the appeals.
For 2A9, 2A10, do I have a motion?
So moved.
Second.
Roll call, Amy.
Ms. Ballard Croft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese, Ms. McCory,
yes.
Mr. Brett,
Yes.
Ms. Watson,
yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes,
Motion passes.
all right.
We have, thank you. We have a complaint following public hearing. It is agenda item 2A11, Eckhoff versus Outrage of Kankakee County, Inc., 24 CD 3. I have an appearance for the respondent from Scott Erdman. Is Mr. Erdman present?
Yes.
Is in Chicago? All right.
Excellent. And the complainant is not present. Is that correct?
He's here, John Fogarty for the complainant.
Okay, excellent. I will read my recommendation and then the parties can address the board. Complainant Eckhoff filed a complaint alleging, among other things, that respondent Outrage of Kankakee County, Inc. failed to disclose independent expenditures of $1,000 or more for a series of radio ads aired in February 2024. This portion of the complaint was found to be filed on justifiable grounds by the board and referred to public hearing solely for the purpose of determining whether there was a violation of section 9-10E for late disclosure of 3 expenditures of $1,000 or more. Specifically, the 3 expenditures were paid to media companies in the amounts of $2,512, $3,000, and $1,005. The parties were both represented by counsel who diligently and cooperatively worked together to reach joint factual stipulations, which obviated the need for an evidentiary hearing on the facts of this case. The hearing officer was able to use those facts to offer a recommendation in this case based on the law applicable. The hearing officer recommends, and I agree, that the committee violated section 9-10E by failing to timely disclose independent expenditures of $1,000 or more. I recommend adopting the findings of fact and conclusions of law on page 83 of your packet in their entirety, except as to finding of fact 2, the date February 20th, 2024 should read February 20th, 2025. It was a typo. The hearing officer recommends, and I agree, that the committee should be ordered to file a D1 statement of organization and quarterly reports disclosing these 3 independent expenditures, as well as any other contributions and or expenditures required by Article 9. The committee should also be ordered to comply with this order within 30 days or face a potential $5,000 fine for violation of a board order. And normally the complainant could address the board first.
And that's John Fogarty. Mr. Fogarty, if you would please state your name and spell it, please, for the court report.
Yes, John Fogarty, Fogarty, counsel for the complainant here. Thank you for your time today. Mr. Erdman and I did indeed diligently work on a stipulation of facts in this matter that obviated the need to go to a full public hearing. And the facts are undisputed. Indeed, 3 independent expenditures were made, each of over $1,000. We concur with this recommendation, the findings of fact, but I would also ask that a penalty be assessed for the failure of respondent to have filed any B1 for any of these 3 admitted independent expenditures over $1,000. That's missing from the recommendation, and that really was the only issue that that went to public hearing. So I would ask that an appropriate penalty be assessed. My reading of the statute is that a first offense is $500, second offense is $1,000, and third offense is $2,000. And while the conclusions of law in the hearing officer's recommendation permit this committee to form itself within the next 30 days or face a fine, it should be noted that while that issue was not part of what made it to a public hearing, this committee did participate in a local election making these electioneering expenditures and did not ever form itself. And that in and of itself is also a violation of the statute, calling for it's 9-3, late filing of a statement of organization. It's $50 a day, not to exceed $5,000 maximum. I'm not sure why, if it is admitted that this occurred, that penalty should not also be applied. So
Go ahead.
that's it.
Okay, thank you, Mr.
And I
Fogarty.
agree with Mr. Fogarty that fines should be assessed and they will be assessed. The reason they haven't yet is because they have not yet filed the quarterly reports to state the date on which each of these filings were made, or rather the dates of deposit or the dates of expenditures, what have you, need to be established in order for board staff to be able to calculate the proper number of the fines. So ultimately, not only will fines be calculated for those 3 expenditures, but once this committee catches up on all of its quarterly reports, it will also be fined for any late A1s. It will be fined for late filing of each quarterly report, which at this point, dating back to early in, I'm looking at okay, so these ads were February 2024. So we're going to be looking at fines dating back at least a year and a half. So I imagine that the fines that will be calculated will be quite substantial. And they will be calculated as soon as those quarterly reports are filed and received.
No problem with that at all.
Scott Erdman, ERDMA.
Hi. Just a second, sir. I'll call on you in just a minute.
Okay, I'm
please.
sorry.
I just got a good reminder from Mr. Newman that for B1s, we can only fine back 1 year. So we will be filing back 1 year, but they, again, will be substantial because the committee has never filed anything before. So I still expect substantial fines.
All right, thank you, Marnie. Mr. Erdman, please state your name and spell it, please.
Scott B. Erdman, ERDMAN.
You may proceed.
I concur with the hearing officer's recommendation. The parties came together to file this joint stipulation to put the matter to rest. We heard earlier, ignorance is, no excuse for a violation of the law. This is actually 3 different transactions, but it's 1 cycle, 1 candidate, basically 1 violation of someone who did not know what they were doing. The board is here to enforce the framework of the statute and ensure that compliance is had, and that's what we got to with this joint stipulation. The joint stipulation let us end it without a evidentiary hearing, and the hearing officer's recommendation should be enough to put the matter to rest. And going after thousands of dollars of fines after the fact, I guess we'll have to come to the board with that afterwards. So
I'm sorry, I didn't hear the last sentence.
as far as thousands of dollars of fines after the fact, I guess we'll have to address that when the board notifies us of what they think the fines should be.
Great.
So
Marnie?
And Mr. Erdman, just to let you know, those fines will be assessed as part of our regular process. You will have an opportunity to appeal those fines. You will have an opportunity to make any settlement offers, and the committee still has a lot of due process to go through before those fines are finalized.
yes, that's what I acknowledged.
Is there any questions of either party?
Yes, I have a question.
Yes.
You say
Mr.
that's what you acknowledged?
Pardon?
Your statement was, that's what I acknowledged.
Yes, it was.
So my understanding then is that you acknowledged that there would be, or there could be, additional fines in the future, and you would address those in the future in your stipulation. Is that correct?
No, they would be addressed in the future. There isn't any stipulation as to fines made or discussed or included in my comment. If the board notifies us of fines, then we'll, as the counsel for the board said, we'll have our due process and we'll return.
Thank you for the clarification.
Is there any other discussion? Now, do I have a motion?
A motion to accept the report of the hearing officer and the general counsel, and to make sure that the respondent be ordered to submit these new filings and reports within 30 days, or they will face an additional penalty not to exceed $5,000. We greatly encourage, the sooner the better, I think.
We're
Great,
ready
and-
to do it. We're ready to do it right away. We're looking to-
And how would you like me to amend this?
And if I may, if I could ask you to amend it, just I want to make sure it's very, very specific what needs
Please.
to be included, so that way
Please.
the complainant knows what they need to do. So the motion could be that the committee should be ordered to file a D1 statement of organization and quarterly reports disclosing independent expenditures of $2,512 to Star Radio, STARADIO, $3,000 to WVLI The Valley, and $1,005 to WIVR River Country, and reports disclosing any other contributions and or expenditures required by Article 9. The committee should also be, the committee would also be ordered to comply with this order within 30 days or face a potential $5,000 fine for violation of a board order.
That is my motion.
Do I have a second?
Sorry, who said that?
Catherine.
Thank you.
Amy, roll call, please.
Ms. Bellicroft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese? Yes. Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Durbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
All right. Other campaign disclosure items, Marnie?
Yes, agenda item 2A12. We do need a vote on this. It is to enter the assessment board orders on pages 113 to 118 of your packets.
Do I have a motion?
So moved.
Second.
Amy, roll call, please.
Ms. Bellicroft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
And for agenda item 2A13, that item is informational. Before we head into executive session for closed preliminary hearings, I know we have parties present on 2A14. Is there anyone here on 2A15 Morris for Citizens for Chris Metcalf?
Yes.
Anyone in Chicago, Jack?
Yes.
Mr. Fogarty?
So,
Yes.
Mr. Fogarty, you're there on behalf of respondents, not
That's,
complainants.
that's correct. That's correct.
Okay, well, normally under these circumstances, when a complainant does not appear, we give the respondent an opportunity to decide, would you rather that the board dismiss this case for want of prosecution, or would you rather go forward with a ruling on the merits?
We'll take a ruling on the merits here, please.
Okay. All right, if there's a motion to go into closed session pursuant to section 9-21 of the Election Code and section 2C4 of the Open Meetings Act, that would be wonderful.
Do I have a motion?
So moved.
Second. It's been moved and seconded. Roll call, please.
Yes.
Ms. Bellicroft?
Sorry, yes.
Ms. Craig?
Jumping the gun.
Ms. Genovese? Ms. McCrory?
Yes.
Mr. Pratt,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yeah.
Chair Donahue.
Yes.
Motion
If you'll-
passes, and I'll need a moment to stop.
Make sure that the room is clear in Chicago.